Okay, so yes, the book has just come out, and what I'm going to do is talk a little bit about, I'll give you just a general overview of the arc of the book, but then I'm going to focus on the chapter that I distributed particularly on the role of lawyers and specifically the ABA in both building and perhaps keeping locked in a platform that's not working as well for us today. So the book and a lot of the work I've been doing over the last several years with Barry Weingast, who's visiting this semester at Northwestern here, and writing with Dan Rodriguez, I see there. Hi. So Barry and I have been working a lot theoretically on the question of, well, what is law in the first place? And the starting point that we're adopting theoretically say, well, look, let's not assume that law is by definition the set of rules written and enforced by the state. That's generally our dividing line between law and social norms, is to draw that differentiation. And so I think it's neither accurate historically nor very helpful from a policy point of view. And that's my starting point in the book. What I'm trying to do in the book is, first of all, situate the evolution of what I call legal infrastructure in the process of developing platforms for successively more complex systems. Now, by legal infrastructure, I simply mean it's not only the rules on the books, it's not only your legal system, it's the whole collection of stuff that researchers here, of course, are well familiar with the difference between what's out there and what actually produces legal conduct on the ground. So that's the rule on the books versus the rule on the ground kind of stuff. It's the practices, the norms, the cost, the way the markets work, all these things that affect the capacity for an entity to say, here are the rules, and to actually have that show up on the ground in the way people behave. So what I start off in the book is to try and situate the evolution of legal infrastructure, really going back, we go back to primates. I think there's something very important that happens at the human boundary, but I felt I had to address a little bit of the literature on the evolution of morality to say, well, it's really once we get to humans, we have third-party enforcement of rules, and that's what's really critical about understanding the evolution of law. And that as we grow more complex, we need different kinds of platforms to support the achievement of social order in light of increasing levels of complexity. And I emphasize that the increasing levels of complexity in society, in the economy, it's endogenous. It's a function of the fact that as we have successful economies and social orders, things become more differentiated. We have increasing specialization, increasing division of labor, and so things become more complex. That's a natural process that we follow. And in that long historical, from that long historical perspective, so if you go back, 4,000 years or more to Hammurabi's Code, which is, of course, the first written evidence of something that's very distinctively legal. I suspect it looks well enough developed that probably it exists before there's writing, but it becomes harder to establish that. And at what point do we draw the distinction between purely organic social order and what we think of as deliberate legal order being a kind of order that you have the capacity to move around, so you have the capacity to do policy. That's what makes it important. The nation-state model of law is relatively recent. It's 200-300 years old, and yet it is today what we take for granted as what we mean by law. We mean governments, we mean states, and part of the story in the book is to say actually that way of thinking is limiting our ability to think about how to face the future. So that nation-state model of law equals the rules written and enforced by government is actually relatively recent. So I want to emphasize that. And then to emphasize that the development of that nation-state model served very well as a stable platform for the development of the industrial economy and the mass manufacturing economy of the 20th century. That economy, in fact, has done so well, it's become a much more complex global economy. I am emphasizing the economic nature of relationships in the book, but not to the exclusion of social, because that's obviously a key part of building it. But I am focused on the economy. And so the argument in the book is that the platform that was built over the 20th century 19th and 20th, late of the 19th and the 20th century, which served very well, I think, to stabilize the growth of the industrial and mass manufacturing economy, is now sort of hitting its limits with its ability to deal with a complex global context. So the book we look at, so we have, significantly increasing rates of cost. That's something here that people think and write a lot about, of course, with access to justice. We have far more complex legal sets of relationships. And I also make the claim that what we see is a problem with quality in the economist sense of, one, how well are you satisfying a differentiated demand? So increasing sense, and this is from interviews I've done with general counsel, and if you look at surveys of this now on the commercial side, we know that we have access problems on the ordinary people side. On the commercial corporate side, the message from a lot of people in business that we just can't find the kind of legal work that we need. So we can relate this to what's happening in the large corporate law firm and in law schools and to all of us. I think is a growing disjuncture between what a complex global economy needs and what our current legal infrastructure is delivering. So a good chunk of the book is spent defending that proposition. And then I'm making the claim that in order to adapt and provide a better platform for that complex global and obviously digital economy, we need more open and competitive markets for the production of legal infrastructure. And by this I mean more open and competitive markets for lawyers and markets for the rules themselves. So we need to recruit the benefits of markets in problem solving to the really hard problem of how do we develop sets of rules that will regulate autonomous vehicles, manage global supply chains, deal with challenges of sustainability in a global environment. I think we've hit the limits of what we can anticipate doing through our existing largely state-based, government-based, and nation-state-based methods. So that's the pitch of the book. Oh, after watching Trump, I'm thinking I should never drink water while I talk. Okay, I promise not to say wrong. So what I want to talk about today, though, to focus on is chapter 5 in the book, which talks about building a stable platform for complexity, which is looking at the role of lawyers, and in particular the ABA, in first of all helping to build that platform for the mass manufacturing economy. I think I'm going to beat up on lawyers in the ABA a little bit, but I want to start out by saying there's a lot to be proud of. There's a lot that was accomplished through the formation of the ABA and the efforts of the ABA, particularly at the beginning of the 20th century. But now lawyers and, yes, the ABA are impeding the building of the platform that we need for a digital global economy. And this is not just about access for ordinary people, which I know is a major issue of concern for researchers here. It's about the corporate commercial, supporting the corporate commercial sector. And the last third of the book is focused on the BOP, the bottom or the base of the pyramid, the 4 billion people living around the world outside of any formal, functional legal infrastructure. And because I'm emphasizing in the book, it's not, a lot of people are unhappy about law, as you know, will say, we need less of it, get rid of the lawyers, get rid of it, and saying, actually, that's the wrong answer. Legal infrastructure is the most important platform that we have. It's what we build everything else on, all our other platforms, transportation, communication, the internet. Everything else is built on a stable platform of rules. And today I think that means legal infrastructure. So I think this is quite critical. It's critical globally. It's critical just about wherever you want to look across the social spectrum. And that's why I think the aim of the book is to raise the profile of that issue and to say we need to be focused on the production of legal infrastructure. And to be honest, part of the pitch of the book is to say to a bunch of people who aren't lawyers, pay attention. Because in fact, lawyers are not yet doing a great job of getting us to where we need to be. So that's going to be my primary pitch here. Apologies, I know that we got a lot of lawyers in the room. Okay. So first of all, what's happened over the last couple of hundred years? It's really important, of course, to put this in the context of the last 200 years have been a period of phenomenal growth, phenomenal economic growth. Average life expectancy has gone from 36 years in 1800, doubled to over 75 today. I think it's maybe even close to 80 in some parts of the West. This is in the West. This is in the West. This is in the West. You have to go back to the economic conditions in around 1300, maybe 1500, to get to line up with where parts of Africa are today, or Central America. $1,500 in per capita income in 1800. We're now many, many, many times above that at 35,500. So it's been a period of phenomenal growth, and far faster. So it's exponential in the sense that if you go back to the year 1000, you get significant growth in the 700 or 800 years from that point. But it really takes off, of course, with the Industrial Revolution in the beginning of the 19th century. So, so that's the background of what's been accomplished. Now I want to think about a little bit more detail about what that economic environment looked like. So in around 1800, 1820, depending on where you measure it, and this is now going to focus on the U.S., 90% of the population were farmers. What industry there was mostly cottage industry, which means people working out of their homes, and very small scale. There's only a handful of firms in the U.S. that have more than 50 employees at this time, and the largest are no bigger than a couple of hundred. So it's relatively small scale, and only 5% of the population is living in cities. By the time you get to the end of the 19th century, we have a significant shift in the nature of the economy, and therefore what's happening with the population. Only 40% of the population are farmers. I think it's down to like 2 or 3% today. It's but 40% at the turn of the 20th century. And we're starting to see the emergence of mega firms. And Alfred Chandler, the beginnings of the world that Chandler describes by the middle of the 20th century, with the vertically integrated mega firms, vertically integrated from raw materials and transportation, so through the railways, to manufacturing, marketing, distribution, all the way from soup to nuts within a single entity. I think around this time, around 1900, about 25% of all output is coming out of the top 100 firms in the country. So dramatic change in the scale of activity. And now 50% of people are living in cities, so significant change there. So I want to look at what's happening in terms of the legal environment in that same period from 1800 to 1900. So I'm emphasizing here, remember, the building of a platform on which to, the creation of a platform on which to build all of that amazing stuff that's happening during the 19th century. So if you go back to the beginning of the 19th century, if you look at the legal landscape, what our legal infrastructure looks like, it's relatively simple rules. You've got contract and property, partnerships, and small corporations. Remember, it's a small-scale business, so there's very little need for large-scale entities, of course. There is actually a reasonable amount of regulation going on, but it's very local regulation. It's at the town or the market level, and it's of a relatively undifferentiated set of goods. So it's regulation of bread or leather, tanning, and so it's there is regulation when you can sell things, where you can sell things, quality levels, and so on. But it's very local, and it's of looking out at a market that's relatively undifferentiated set of goods. We have courts are primarily at the local level and are to some extent kind of disorganized because they're dealing with local issues. Everybody's, it's what's happening here. We don't need to have an organized system of jurisdiction between our courts and their courts because nobody's going to their courts. It's just a local court. So I mean disorganized. It may be disorganized when you walk through the courthouse door as well, but I mean in terms of the system here. We have overlapping and ambiguous jurisdiction, again, because rarely are people pressing on where is it supposed to be. And of course, we have at the beginning of the 19th century a wide open market for lawyers. Anybody can practice as a lawyer. There is no educational requirements. There's, at most, you may have to go into the local judge and answer a couple of questions to get the right to appear in court, but there are no restrictions. So this is the Abraham Lincoln model of, read some books and keep on reading. Start practicing, keep on reading. By the time we get to the end of the 19th century, of course, that's starting to change very dramatically. So at the same time as we're getting the railways building up and the vertically integrated mega firms emerging, remember the first federal regulation is Interstate Commerce Commission, regulate the railways, set rates, and in 1890, the Sherman Antitrust Act. Because of the agglomeration of power. We're starting to get expertly drafted and much more complex sets of rules. We're starting to see regulation at the state and then at the national level and much more extensive. We're starting to see standardized, even uniform laws and procedures, rationalized jurisdiction to resolve the issues between different courts and lawmaking bodies. And we, of course, see the emergence of standardized educational requirements and licensing for lawyers, so moving to a closed market. So one of the points I want to emphasize, and in a sense, the changes in the legal platform over the 19th century mirror the changes in the the nature of the economy. So the 1800s, both the economy and the legal platform are highly decentralized. They're relatively simple and small scale. They're somewhat chaotic, and they're local. By the time we get to the end of the 19th century, we're seeing vertically integrated and centralized on the economic and the legal side, increasing specialization and differentiation. So lawyers are starting to see, it still takes a fair bit of time for significant specialization among lawyers, but we're seeing more specialization with legal functions, just as we are in economic production. Both systems are much more rationalized and organized. One of the things, of course, it's important to remember that Chandler is emphasizing, the name of the book is The Visible Hand. And it's not about markets, it's about basically internally, centrally planned activity. So there's lots of central planning both within organizations in our market economies and of course around the world. And I'm not going to emphasize as much what's happening globally today, but central planning, at the turn of the 19th century, particularly after the First World War, everybody thinks this is what you need. You need rational capacity to control things from the top, or else it's going to be utter chaos as the economy gets more complex. And it's primarily a nationally based economy. There is international trade, but most companies that are headquartered in the U.S. are doing their activity in the U.S. There's some importation of raw materials. There's some shipment of final goods, but for the most part, what's happening is at the national level, and you can regulate at the national level, or at least even if it's not federal regulation, you're within an organized system of it's happening at the nation state, within the nation state. Okay, so I want to emphasize now, get into now what role are lawyers playing is how do we get to this? But this is, a key point, you're getting a platform that works very well for to stabilize the growth of the 20th century, which is pretty phenomenal. So of course the ABA gets founded in 1878 in Sarasota Springs with a very self-conscious goal of bringing order to what's perceived as legal chaos. Now, of course, we don't want some of those folks practicing law, but there is a very clear motivation to say this is a bit of a mess, and that's a quite accurate depiction of what the platform looks like at the time that a lot is happening, is changing on the economic front. So to bring intelligent control And this is the era of scientific rationality and the Weber's observation that one can in principle master all things by calculation. Right? That's kind of the ethos of the economy, and that's the ethos of the efforts to bring order to the legal platform. And to do this, the lawyers organizing the ABA, which for a long time, as you know, was a very small proportion of the legal profession who are participating in this, very elite group that are participating. The goals are to standardize, create uniformity, introduce and require educational standards for the practice of law and admission standards, and to develop exclusivity over the market for lawyers. So let's look at each of these in turn. So on the uniformity and standardization front, the agenda for the ABA right from the get-go is to look out at the entire legal landscape and say, how can we improve the quality and standardization, uniformity, and organization of this? So we have the development of the advocacy by the ABA and the development of state commissions on legislative drafting in order to get some more expert advice into drafting. You get the codification movement, both in procedure and substantive law. You get pressure to bring order to the law reports with standardized classification and indexing of both decisions and statutes. The rationalization of jurisdiction, right? Clear sets of rules about which court is supposed to decide which matters, expanding the Supreme Court, creating the appellate courts at the federal level. ABA drafts and gets Congress to pass a National Bankruptcy Act. It's one of the first things they're doing in the late 19th century. The development of a federal code of procedure with a goal that will inform and hopefully spread into the states so that we'll have uniform procedures, state and federal. And then uniform law reporting standards across the states. Eventually, we're moving into the development as we start to get significant size regulatory agencies, the development of administrative law, federal regulation to deal with issues that aren't well dealt with at the state level. The ABA plays a very important role in the development of the Uniform Law Commission with model laws and uniform law recommendations. And of course, we also get the American Law Institute. Now, I actually haven't tracked down the relationship between the ABA and the ALI. Does anybody know it?
Yeah.
Separate. No role.
Functionally, structurally separate organization.
Right. Yep. Right. So I'm just curious if there was a role for the ABA in getting that established. But at any rate, we get a coherent group saying, okay, we're going to review common law areas and publish restatements and so on. So that's and this is where I say there's a tremendous amount of value that comes from this kind of work, the standardization and the creation of this standard platform. So we also get the effort, of course, to improve the educational standards. In the 1890s, no state at the time requires legal education or a bar exam, and 7 out of 76 law schools, only 7 out of 76 law schools require even a high school diploma in order to take legal education, and local courts are doing admissions. And the ABA, as of early on, right away, is recommending that states should establish that only the highest court in the state can admit people to the bar, and that they should require a minimum of 2 years legal education in a facility with, sounds familiar, adequate library and standards. And by the 1940s, it takes a while, but by the 1940s, this is what has been accomplished through the ABA leadership and then implemented at the state bar level. We have systems for identifying what's approved legal education. We have admissions controlled by the state Supreme Court, and that's required in almost all states. I think admission by the state Supreme Court is required in all states. It's the ABA approved legal education that's a couple of holdouts, including still, of course, California. And we have the bar associations firmly in the position of exercising disciplinary control, or what an economist would say is just regulation over how lawyers are allowed to Now, on the exclusivity front, which is the development of the idea that this is the only way that people can be trained and participate in the market for lawyers. So from in the first part of the 20th century, we still have the hangover from the 19th century, of course. Anyone can practice law and seek admittance to the bar. And at the time, in the beginning of the 20th century, lots of corporations are starting, which of course are just starting to emerge. Remember, 19th century, you don't really have these kinds of larger scale organizations. As they emerge, one of the things they start doing is to participate in supplying legal goods and services. So you get banks, trust companies, automobile clubs, trade associations. They're all out there offering their customers or their members legal services. And few states have any statutes in place addressing that and treating that as anything like this idea of that's an authorized legal practice. You're not allowed to do this. Now, this is happening in a lot of professions at the same time. Doctors and so on. This is a very frothy time for lots of lobbying of legislatures to enact laws that will restrict the practice of various professions to those that have been duly licensed and maintain their license with the professional regulatory, generally a self-governing body. And I'm sure many of you already know the story. So in the 30s, following the Depression, there's a lot of economic pressure on lawyers, as there is on all the professions. And the ABA undertakes an investigation of the unauthorized practice of law, starts on the legislative slog to get those statutes passed. At the same time, it's actually involved in the effort to get the courts, to get Congress to adopt procedural rules for federal courts in particular. And at some point realizes actually we've got another strategy here that we can follow, and that is to say, well, wait a second, the courts are an independent branch of government, and courts should, let's start with procedures, be recognized as having inherent authority to decide what the procedures are in their own courts, that legislatures shouldn't be telling courts how to decide cases. And that's a challenge. And Congress ultimately accepts that view, that the courts have inherent authority to determine their own procedures. And this sort of emerges as, here's another way to manage all of the provision of legal services by people who are being, and entities that are outside of the model we're trying to create of you get 3 years of legal education, you get admittance to the bar, and that's to vest that capacity to make the determination of who can practice law and in what format, to embrace that within the inherent authority of the courts to regulate the legal system generally. So it's like the success with the court procedures provides an avenue for getting out of having to go to the state legislatures case by case and get legislation passed. So the bar associations start litigating, challenging these kinds of entities, the banks and the trust companies and the automobile clubs in court, and when they don't have a state statute to draw on, are appealing to the inherent authority of, and so this, I'd emphasize, so the inherent authority of state Supreme Courts to regulate the legal profession, which we kind of take for granted now, is basically invented through the efforts of elite lawyers and with leadership from the ABA during the 1930s. And it's especially powerful, of course, because it's a claim that's rooted in state constitutions. So it's not a legislative move. It's rooted in the Constitution, and that's today one of the most difficult pieces of the regulatory environment, is to say, well, this is, you can't even go lobby. You could go lobby the legislature of Illinois to say we should have a different set of rules governing who and how you can practice law and supply legal services. But lawyers have pushed back on that to say, wait a second, no, the legislature doesn't have constitutional authority to step in. That's actually vested in the state Supreme Court. So it's even quite different from the regulation of the medical profession or dentists teeth whitening, anybody? And it practically wrested control of the legal markets in bar associations, because of course courts are not actually set up to be policy-making institutions. They don't have policy staff, they don't have policy budgets, they don't have time, they're not funded well enough to decide the cases that they're getting, so they are not in a position to devote resources to the development of policy, and particularly if we think, as I'm going to emphasize, a lot of what happens in our policy about our legal markets is fundamentally economic policy. It's determining not just how people who want to buy legal services are being treated, but also how well that platform is serving to undergird the development of our economy, so that economists like me could and should and do have a lot to say about what would be appropriate legal policy. And just as a side note, of course, that's what we see happening in other parts of the world. So I'm sure most of you are familiar with the changes in the UK with the Legal Services Act. Those are triggered by antitrust concerns and economic analysis, saying, we need to have a justification for restrictions on that market. That's economic policy. And that's where the pressure has come from, and it's especially well embedded and insulated from that here. So, what do we mean by our? Now we're in the era of what I'm just going to call closed. You can call them heavily regulated, although it's a very strange kind of regulation. Closed legal markets. So, what do we mean by that? It's all very familiar. Only JDs and in-state bar licensed attorneys can provide any form of legal assistance. Again, that's more restrictive than in other environments. In the UK, the provision of legal advice and drafting services has never been restricted to licensed professionals only. Organizations and corporations can't provide services. That's, of course, our corporate practice of law doctrine. And lawyers can't work for or with organizations, corporations, or non-lawyers. That's our corporate practice of law doctrine, that's our fee-sharing rules, and that's our disciplinary procedures or disciplinary rules for lawyers, making it unethical for them to participate in an entity that is otherwise engaged in the unauthorized practice of law. And this is actually a very effective tool, because you don't have to go after the corporation that is trying to hire lawyers or contract with lawyers to provide services directly to the public. You just go after the lawyers, say you can't do that or you lose your license. And this has actually been, I think, an unfortunately effective technique. Is, if you threaten lawyers that if they participate in an online legal question and answer platform, that they're violating their own ethical rules, and that's, you don't have to go after the platform. You just cut it off from lawyers who are worried about their disciplinary committees. So how does this? So the claim in the book is that these limited, and I should say this, I think it's the worst of all in the US. Canada is extremely close, and I can't really claim to say, I know what the legal professional regulation environment looks like around the world, but it's certainly about as bad as it can get, I think, here. And so I'm emphasizing in the book the impact on access to justice for ordinary people, the development of what the corporate and commercial world needs, and also, I won't talk much about this today, but the development of how we really do build the legal platforms that we need for the other 4 billion in the world. But let's think first about how does that existing platform, which was so effective at least for everything except maybe access during the 20th century, how does that limit? So the problem is cost. And those of you who've seen me, you're going to see a few numbers you've seen before. I'm trying to look around the room, see who's already seen my numbers, but you can guess. Okay, 62%, everybody in here knows what that is. That's basically the average across state legal needs surveys of the percentage of people who say, yes, I have one of those problems you've listed on that list. And people who say that they have one generally have 3 on average. So if you take these are households actually, generally they're households. This is all just very rough back of the envelope. You take 62% times 3 times 125 million households, you get 230 million problems. And we're not quite sure, is it over a year and a half, 3 years? And there seems to be some consistency. I've seen now legal needs surveys in 30 countries around the world. It's amazing how consistent the number of about half and 2 or 3 each if you got them is. Okay, so if we were paying lawyers $200 an hour, which is pretty much, again, we don't know of the data, we don't have good data, it's about rock bottom on what you can find lawyers practicing for in the small firm and solo practitioner market. So that's $46 billion. So for those of us who think we can solve this problem with legal aid, no. I really want to emphasize that's drop. We should have lots more legal aid than what we have. I'm a total supporter of expanding legal aid, but the dimensions of this problem are far outstrip anything you could accomplish with legal aid. And so I like to say to bar associations, please stop talking about legal aid because we're not focusing on the big thing. I realize we need more legal aid. I don't actually mean that, so I'm talking to the camera here. Or we could do it with pro bono if you could get every licensed attorney in the United States to put in a minimum of 200 hours of work. Now, what does this actually get people? 1 hour of help. 1 hour of help. $46 billion per hour of help for everybody, or 200 hours of pro bono per lawyer for everyone. So, scale, right? Massive. So an economist have to draw a demand curve. This is a very schematic. It should actually go way out in that tail. So what are we doing today? We have a market in which the average rate in the big law context about $600 an hour. Again, we don't have good data. About $450 in the small and medium-sized business market. 200. Again, we don't. The averages that come up in surveys are really closer to 250, 260, 270. I know that there are lawyers who are willing to work at 150 and so on, but again, we don't have good data. We need better data. 200. So that's reaching people who have some wealth and no choice. We got a massive tail. That's why this thing, if it should fit, it should go way out there. Everybody else who, this is just schematic to show you'd have to get the effective hourly rate down significantly to provide legal services to those folks. So first thing we think about is, can we lower that hourly rate for existing practitioners? That $200, can we just lower that? Are lawyers being greedy? Are they overpaid? And the answer is no. That number is not a product of greed and being paid too much and rich lawyers. That market, as many of you know, the small and solo practitioner market, is highly competitive. The bottom 40% of law firms, we don't really know what solo practitioners make, but anybody's got data. I'm trying to work on this with Ben Barton now. So I've looked at the Census of Economic Services. This is 2012 data. The bottom 40% of law firms in the US average $135,000 in revenue. So if you want to think that the bottom 40% probably line up not too badly with solo practitioners, which are maybe about 40%, 45% of the private practice market. They have an average of $45,000 in payroll. Oh, sorry, these are only ones that are paying payroll. So these in fact, there's a whole bunch of that are not even counted in here because they don't hire anybody. But they about an average of $45,000 in payroll. So that's for maybe a paralegal, administrative assistant. Now, you got to take 135 and take out 45,000. That gets you to 90,000. You have to pay everything else out of that: rent, overhead, insurance, technology, everything else. So, what are they taking home? Maybe, I don't know, $60,000. They don't have the number on this. We're trying to piece together other ways to come into this number. The point is, that's not a really high salary for a professionally educated graduate, holder of a graduate degree. And notice that if they were earning that $200 an hour that they're charging in the market full-time, 40 hours a week, 48 hours a year, they'd be making closer to $400,000 a year, and they're probably making 60. So what does that tell us? It tells us that there's a huge amount of inefficiency in that $200 rate, right? What's in there? There's unbilled hours, there's looking for clients, there's not collecting, there's keeping clients, managing client complaints, investing in legal knowledge and technology, and just running a business, because our models require that lawyers providing services at this level operate their own business. So notice that that's $40 out of 200 that's actually going to pay a lawyer for doing legal work. So the other 80% of that fee is effectively the, I would claim, massive inefficiency in the delivery model. Or almost 80% of that is not law. It's running a business. And that's, so when I emphasize the importance of opening up markets, it's because the only way we shrink that, we can't shrink the take-home for lawyers in that part of the market. They'll just stop being lawyers. They're already probably unhappy that they're lawyers. We need to shrink that part of things, reduce that cost. So how does the existing platform inhibit that cost reduction? Well, we have high opportunity costs. You only allow JDs, that means these are people who don't have to be lawyers. They could go off and get an MSW, they could go to business. It's a high opportunity cost. I emphasize that more than the legal education costs, because legal education is in the past and your opportunity costs are in the future. So just lowering legal education costs will not significantly change the dynamics here. It would obviously be a good thing, but it wouldn't do everything. We have restrictions on scale and branding, and I think this is quite big. That's coming from the ban on corporate practice, the requirement of state-by-state licensing, so you can't get national scale, much less global scale, advertising rules, and then the UPL risks that for lawyers who might participate. So I'm on LegalZoom's Legal Advisory Council. I don't have a financial interest in the company, but I'd say, that's the kind of brand and scale that you'd like to be able to extend beyond document production to, talk with a lawyer now. I want them to be able to hire lawyers and put them on the end of the phone line, pay them $75,000 a year, which they would do, and let LegalZoom figure out the technology and customer satisfaction and pricing and so on. And we have a lack of innovation and technology. We're still performing law in very much the ways that we were 100 years ago, email and keyword searches notwithstanding. And that's coming again from the limitations on the corporate practice of law, our rules about fee sharing, so that even if we didn't want lawyers to be employed by corporations, they can't enter into very standard, ordinary, bread and butter legal economic arrangements which share profits and revenues with somebody, so that you create incentives for both sides to invest in building a better product and figuring out how to reduce costs. So I've talked about the access piece. Let me just also talk a little bit about the complex global digital economy. How is this platform inhibiting our adaptation to that economy? Why is it that the General Counsel of Cisco and Google and Apple, when I speak to them, say, we can't find what we need in the legal market. We are not getting the kinds of services that we need to manage a global, digital, complex environment. So why are we not getting the kind of innovation there? Number one, we have a very restricted and homogeneous pool of potential innovators. It's JDs. It's lawyers everywhere. Everybody went to the same kind of law school. Everybody talks to other lawyers. They work mostly in work environments with other lawyers. And quite apart from any, I don't think lawyers are inherently not creative. I don't think law students are inherently not creative or risk averse. It's structural. It's created by the environments in which they work and who they speak to and what they get exposed to. They're not working on teams generally with non-JD trained, so we all think alike. Right? Usually when I give these talks and ask how many people are not lawyers, like the number of people who are not lawyers or don't have legal training in the room or don't spend all their days with lawyers is very small. Don't have access to diversified risk capital. Of course, to get innovative technologies and delivery methods, it's risky. There's lots of failure involved. And you need access to diversified risk capital, but you can't get that because of the corporate practice of law ban. This is not about listing law firms publicly. I don't really care whether we ever list law firms on stock markets. I think that's a very unimportant piece of the story. But it's about the engineers who just left, we think, Apple, who used to be working on their autonomous vehicle project, who 1,000 of them who are, highly expert in the questions and issues about how do you regulate that self-driving car. If they have some great ideas, I want them to be able to get a startup and get some financing and build that out and bring in lawyers as is appropriate to do that. And we have the limitations on our business models and those risk incentive contracts, because of fee sharing and the corporate practice ban and the UPL risk. So these are these are very much related. We don't know what the right business model is to deliver a better legal product. And what's happening now, we have a regulatory regime. Again, kudos to the platform that we built, but it's now heavily, heavily, heavily insulated from change, and reform depends on voting by lawyers who are invested in the platform that we developed to build the fantastic 20th century economy. So we've built this great thing, we then draw a fence around it, and then we say, I used to think that state Supreme Courts, because they are formally, in fact, the regulator, that you could approach state Supreme Courts and say, hey, in the public interest, we should be doing something different. Most of them feel they can't do anything that wouldn't be approved by their bar associations. Washington State, of course, took a slightly different route with the limited license legal practitioners. Still lots of issues because it wasn't supported by the bar. Jonathan Lippman in New York really understood this message. He saw those numbers about 3 years ago and really got it. And so we have unpaid volunteer navigators in housing court in New York, and that's great. But why is he doing that? It's a very difficult terrain to traverse. California Chief Justice will emphasize, number one, they only consider proposals that come up through the bar. And two, they're heavily dependent on the bar to lobby for their budgets in the legislature. So they are not doing anything so at the end of the day, it's what will lawyers support. And that's causing that's a huge cost from an economic point of view. With fairness, of course, access, of course, but we're not building what we need, and we're falling down on our job. So how are you going to build that legal infrastructure for the complex and more inclusive global economy and make it more accessible for all? Well, we need to stimulate innovation. This is what the world is starting to look like, right? Digital, global, very fast-moving. Everybody knows what an exponential curve looks like. There's a great picture I almost put in here. If you look at the adoption of the shipments of mobile phones, the line goes like this. Personal computers goes like this over the last 10 years. Look at the shipment of smartphones, goes like this. It's just that's what exponential change looks like, and that's the environment. That's how fast things are changing, and I think we really need to come to grips with that. We need to build a platform that's global. Local, national, state by state, certainly even national, is not as effective particularly on the corporate side, and it's not helping the bottom of the pyramid folks. So we need more types of legal professionals, open business models, which of course going under the rubric used in the UK of alternative business structures. Really important to emphasize, we need entity regulation. Creating ABSs does not mean creating unregulated corporations that can do whatever the heck they want. The opposition that lawyers generally have to the corporate practice of law is very much rooted, and in fact cites to case law that predates the emergence of the regulatory state. There's no such thing as a corporation that isn't operating within a heavily regulated environment today. And corporations engaged in legal services would not operate in anything different. It would still be. And Deborah Rohde and I have a recent paper going in detail about what that regulation looks like in the UK and how it could be adapted to the US. It's all very sensible and easy to do. And we need revenue and profit sharing between lawyers and others to secure those incentives. So we need change in the legal platform that mimics the change we're seeing in the economy, and the way that 19th, 20th century economy, the legal platform tracked what was happening in the economy. We're out of sync. We need to bring it into sync. This is my last slide. So those first two columns are what I already had up here, the highly decentralized going to vertically integrated. So what does the world look like today? It's decentralized and networked. We've had a significant drop in the levels of vertical integration. We have exponential degrees of specialization and differentiation. So maybe you've heard of the concept of the long tail. right? So we're at much higher degrees of specialization and differentiation. We are now in the environment of, we don't think like Weber that you can solve everything with calculation. There's we know we have emergent complex systems in the sense of complex adaptive systems that you try to shape, you try to jump on top of, you try to ride it and get it to go where you want to go, but you can't do it like an engineer and say this, right? The self-driving car is machine learning. It's not programming the car to, in situation X, do Y. You can do some of that, but significant components of artificial intelligence and machine learning are fundamentally responsive training to the environment, and it's global. So I'll stop there.
Great.